This video provides a detailed review of joint development agreements (JDAs) in maritime areas, drawing on various international legal sources, state practice, and academic commentary. It highlights main themes, key ideas, and important facts related to their formation, structure, legal basis, and implications, particularly concerning hydrocarbon resource exploitation and environmental protection. 1. Introduction to Joint Development Agreements (JDAs). Joint Development Agreements (JDAs) are intergovernmental arrangements designed for the cooperative exploration and/or exploitation of hydrocarbon resources in seabed areas, particularly where maritime claims overlap or where resources straddle a defined boundary. They serve as a pragmatic solution to circumvent intractable boundary disputes and facilitate resource utilization. The fundamental basis for JDAs rests on the fluid nature of petroleum or natural gas. If a deposit crosses a boundary, uncoordinated extraction by one party can harm the potential share of another, making cooperation desirable to ensure efficient and equitable exploitation. While often related, JDA and unitization are distinct. Unitization primarily addresses the exploitation of a single transboundary deposit as a unit, typically after a boundary is defined. JDAs, conversely, apply to broader geographic areas subject to overlapping claims, often before final delimitation. 2. Legal basis and obligations under international law. UNCLOS Articles 74.3 and 83.3. JDAs find their primary legal basis in the United Nations Convention on the Law of the Sea, UNCLOS, specifically Articles 74.3 and 83.3. These identical provisions stipulate that pending agreement as provided for in paragraph 1, the states concerned, in a spirit of understanding and cooperation, shall make every effort to enter into provisional arrangements of a practical nature, and, during this transitional period, not to jeopardize or hamper the reaching of the final agreement. Such arrangements shall be without prejudice to the final delimitation. Obligation of conduct, not result. International courts and tribunals, such as in the Guyana v. Suriname case, have interpreted this as an obligation of conduct rather than an obligation requiring states to actually enter into an agreement. States have a duty to negotiate in good faith and adopt a conciliatory approach, but are not legally obligated to achieve a JDA. Restraint. A critical component of these UNCLOS provisions is the obligation of constraint or mutual restraint, requiring states not to jeopardize or hamper the final delimitation. This generally means refraining from unilateral actions that could cause irreparable prejudice, although not all exploratory activities are prohibited. For instance, seismic testing may be permissible, but exploratory drilling causing permanent damage could be a breach. Customary international law. While widespread state practice exists, there is no definitive consensus that a legal obligation to enter into JDAs constitutes customary international law. The practice is not always constant or uniform, and states do not consistently believe they are under a legal obligation to form such agreements. Without prejudice clause. A standard feature in JDAs is a without prejudice clause, ensuring that the agreement does not affect the parties' positions on ultimate delimitation or their underlying sovereignty claims. 3. Models and structural elements of joint development agreements. JDAs vary in their structure and the degree of institutionalization. 3 broad models are commonly identified: single state model, joint venture model, and joint authority model. 1. Single state model. One state manages the development of resources in the disputed area on behalf of both, with the other state receiving a share of revenues. This is the simplest, requiring minimal bilateral cooperation and harmonization, but raises concerns about the managing state's preemptive role affecting the other's claims. The 1958 Bahrain-Saudi Arabia Agreement, where the Fasht Abusfa oil field fell entirely on the Saudi side of the boundary, but Bahrain received 50% of the net revenue. 2. Joint venture model. This model involves an agreement between national or nominated oil companies to establish compulsory joint ventures or unitized transboundary deposits, often with a single operator. The government's role is more limited, nominating companies and approving agreements. The 1992 Malaysia-Vietnam MO explicitly nominated Petronas and Petrovietnam to undertake exploration and exploitation in a defined area, with a coordination committee appointed by the national companies, showing flexibility and simplicity. 3. Joint authority model. This is the most complex model, establishing an international joint authority or commission with legal personality, licensing, and regulatory powers to manage the designated zone. The 1979 and 1990 Malaysia-Thailand Joint Authority (MTJA) is a prominent example. With a strong institutional framework and comprehensive powers over exploration and exploitation, the Joint Authority has juristic personality and consists of co-chairmen and an equal number of members from each country. Common provisions in JDS regardless of the model. Common provisions often include non-prejudice clauses, jurisdictional allocations, institutional arrangements, hydrocarbon licensing regimes, dispute settlement, environmental protection, and third-party rights. These provisions are designed to facilitate cooperative exploration and exploitation of resources in areas of overlapping maritime claims while addressing various legal, operational, and financial aspects. 4. Factors influencing JDA adoption. States consider various factors when opting for a JDA intractability of disputes. JDAs are particularly attractive when traditional delimitation negotiations reach a deadlock due to fundamentally different positions. Economic imperatives. The discovery or strong prospect of valuable hydrocarbon resources often drives the need for cooperation, especially when states cannot afford to delay exploitation. Maintaining good relations. JDAs can foster regional cooperation, enhance good neighborliness, and de-escalate tensions arising from overlapping claims. Uncertainty over resource location. When the precise extent or location of hydrocarbon deposits within a disputed area is unknown, JDAs guarantee both parties a share, reducing the risk of one party losing out entirely after delimitation. Technical and financial capacity. Developing states often lack technical expertise and financial resources for offshore hydrocarbon exploitation, making joint ventures with private entities or other states attractive. Political will and compromise. The success of a JDA ultimately depends on the political willingness of states to make concessions and prioritize cooperative resource management over rigid adherence to territorial claims. For operational and jurisdictional aspects, JDAs entail complex operational and jurisdictional arrangements, jurisdiction in undelimited areas. This remains a significant challenge. Some agreements, like Japan-South Korea, adopt an operator formula, where the authorizing party has jurisdiction, which can shift between exploration and exploitation phases. Taxation and revenue sharing. JDAs establish frameworks for sharing economic benefits and often address taxation. The Timor Gap Treaty, for example, had a detailed taxation code, initially envisaging equal taxation for Australian and Indonesian nationals, with third state nationals paying both with a rebate. Dispute settlement. Most JDAs include provisions for peaceful dispute resolution, typically through consultation, negotiation, or arbitration. Pre-existing rights. The impact on existing concessions granted unilaterally before a JDA is a complex issue. Some agreements, like Malaysia-Thailand, face delays due to the need to integrate existing concessionaires, while others, like Japan-Korea, had discretion to grant new rights, which could sometimes disadvantage original rights holders. Duration and termination. JDAs often specify a period of operation, with provisions for extension if a permanent boundary is not agreed upon. For instance, Malaysia-Thailand for 50 years, Timor Gap for 40 years with 20-year extensions. 6. Environmental protection. A significant and growing aspect of JDAs is the inclusion of provisions for environmental protection and marine pollution prevention. UNCLOS and duty to cooperate. UNCLOS and duty to cooperate. UNCLOS mandates states to protect and preserve the marine environment in Part 12, individually or jointly, and to ensure activities under their jurisdiction do not cause damage to other states. This obligation applies to joint development zones. Specific measures. JDAs include provisions for preventing pollution, establishing safety zones, and developing contingency plans. Joint inspections. Cooperation in JDAs allows for joint inspections to ensure operators adhere to health, safety, and environmental laws. Addressing accidents. Major incidents like the Ecofisk and Macondo well blowouts highlight the need for robust safety standards and continuous monitoring, reinforcing the integration of environmental protection in JDA. 7. Challenges and future outlook. Political instability. Changes in government or ongoing political tensions can undermine the political will necessary for JDA's conflicting claims. The existence of third-party claims can complicate and even impede JDA implementation. Disproportionate control. states are often reluctant to cede significant control or influence, leading to complex institutional structures. 8. Summary. Despite these challenges, JDAs offer a proven and flexible mechanism for managing shared offshore resources and de-escalating maritime disputes, especially in regions with significant hydrocarbon potential and complex geopolitical dynamics, like the South China Sea. The increasing demand for energy and the mounting precedents of successful JDAs make them an increasingly attractive solution.